was this notification that they changed some of the study units around.
Yeah.
Was that
beginning. Yeah, it says like 1 to 17, like they move some around.
That won't affect the way I design the course. Yeah, so don't worry about that. All right, so I want to close the loop on something that we were talking about last time, which was Circular 230, which talks about practicing but before the IRS. Now, Circular 230 is 48 pages, and a copy of it is on our course website. But I want to draw something to your attention, and then we're going to leave that, and we're going to go back to what we started talking about last time, which is filing status. And then when we talk about claiming a dependent, what are the conditions for somebody to be our dependent? So can I take Tanya as my dependent? Or could I take Camilla as my dependent? Or Elam? Come on, Elam, I need to reduce my taxable income. So we're going to talk about whether the individual is a qualifying child or a qualifying relative, and what the other criteria are, which we refer to as tests. So we're talking about the relationship test, the age test. All right, and this is, here we start, this is in chapter 2 of publication 17. So right from the beginning, we talk about filing status, which is very important, and we're going to see why. Because I'm going to share with you what are the standard deductions for these different filing statuses. But I want to, before we do that, I want to close on Circular 230. Now, Circular 230 is actually part of Title 31 and issued by the Department of Treasury. Now, there's Subtitle A and Subtitle B. Now, Subtitle A is parts 1 through 56. So, Subtitle A of Title 31 is 1 through 56, and Subtitle B is what? Parts 57 to, you ready? 910. So our 48-page document, Circular 230, which is very relevant to what we're talking about this semester, is Section 10. That's why if you're reading through Circular 230, which again is on our course website, and you're like, Section 10.1, Section 10.2, Section 10.26 to Section 10.53. In class, where we were going over a couple of examples last time, I was referring to some of those sections. Now, some of you are probably thinking, you know, Section 10. Some of you probably started thinking, well, what about Section 9? What about Section 8? Section 7? Section 6? Section 5? Yes, there's over 900 sections. This document, which is important for our study, Circular 230, is Section 10. So this is part of a much larger document, and this governs the practice before the Internal Revenue Service. Questions about that? So remember, we talked about what it means to be practicing before the IRS. So, very important document. All right, so now, what we're going to do is we're going to go back. I want to talk about filing status. Very critical decision. Whether we're preparing our own tax return or we're preparing a return for somebody else. We need to decide what is the filing status. So at the very beginning of Form 1040, and underneath your name and address, it asks, what is your filing status? So, what are the choices? Well, you could be single. So we need to talk about that. What does that mean to be single? So, yes? I'm hearing somebody say something. Tanya? No? No. Oh, Tamara?
Not married.
No.
Yes?
Independence.
So, if you're single,
Fine. Well,
it's what?
well, single, not married, or any of the others, and no qualifying child.
All right. So, I mean, we don't need to, everything is in publication 17, so we're not sure. We can look it up. Now, single, either we were never married, or we were married, but our divorce decree has been finalized. So, you might have been married previously, but now you're divorced, which means not that you filed for divorce, but that your divorce decree has been finalized as of the last day of the year. So in other words, what does that mean? That means if, as of December 31st, you are either never married or your divorce decree has been finalized, then you are single. So why do I stress that? Because take, for example, you're married. Maybe you've been married 5 years. But in 2012, your divorce decree is finalized. And let's say it's finalized when? Pick a date. September 1st? So September 1st, your divorce decree is finalized. That means you're no longer married, and party! Right? We're going to go out and celebrate, right? Because your divorce has been finalized. So then you're into 2013, and you need to decide, well, let's see. I was married. In fact, I was married for 5 years in our example. And then, on September 1st, my divorce decree was finalized. Now we're already in February 2013, and you come to me and say, you know, Coach, I'm not sure. What filing status should I check? Should I check single, right? Should I elect that I'm single, or that I'm married? Because I was married for most of the year, in fact, up to September 1st, which is, what, 3/4 of the year? So you're like, well, 75% I was married. 75% of the year, 75% of 2012, I was married. So the IRS is reasonable, right, Coach? So shouldn't I be able to elect a married filing status? Either married filing jointly or married filing separately. And I said, we always joke, married filing single. Well, obviously you can't be married and filing single, so it's either one or the other. What do we do? So it says in publication 17, in chapter 2, that as of the last day of the year, that's what we use to determine our filing status. So, if as of December 31st, you were either never married or you were married and your divorce decree has been finalized, then you are single. It doesn't matter. 75% of the year you were married? Well, my condolences. What could I say? It didn't work out. Questions about that? So, you were married once, you're not married anymore. How do we decide? The IRS says, as of the last day of the year, if you were never married or your divorce decree has been finalized, then your filing status is single. Doesn't matter if it was 80% of the year, it could have been, your divorce decree could have been finalized on December 30th. As of the last day, on December 31st, you wake up and you say, free at last, free at last! Thank God Almighty. I'm free at last. Your divorce has been finalized. Then you're single. As of the last day of the year, you're single. So it's not subjective. It's not, we don't need to guess. It's not a gray area. It's very clear. Do we agree? Now, you may not be happy with the IRS's decision or what Congress has written into the IRS code, but that's the code. That's the rule that we go by. So as of the last day of the year. Now, you might wonder, why does it matter? So why would we care if we're electing a filing status of single or head of household? Because head of household is also single, but with a dependent, right? So if you're single and you have a dependent, then your filing status could be head of household. Now, see the segue there? I used the word dependent. So now the question is, that takes us here, which is, well, what's a dependent? How do we know if somebody is our dependent? And in 2012, the exemption for a dependent is $3,800. Am I right, Corinne?
Yeah.
$3,800.
It reduced from 5,000 something to.
I didn't say that was the standard deduction. I'm saying that's the amount of the exemption. So I want to help us kind of understand the implications on our level of taxable income. So you're going to see why the filing status is important to us in terms of how much tax we're going to have to pay. Now, Mohammed mentioned a number like 5,000 something. So the standard deduction for single is, in 2012, is $5,950. Now, the way that the tax code has been written is these numbers, the IRS has what's called a phase-in plan, that they adjust these numbers from year to year to achieve a certain outcome. So everything about the IRS code, the way it was written by Congress, is based on a certain motivation, either to encourage us from doing something or discourage us from doing something. So depending on the particular action or behavior, there's consequences, there's tax consequences. So $5,950 is for single. What about for if you're married, as of the last day of the year, you're married, what is the standard deduction?
Filing jointly or separate?
Filing jointly.
Oh, 11,900.
11,900. And what if filing separately?
5,950.
Now remember, this is for 2012. So 2011, the numbers were different. 2010, the standard deduction amount was different. Now, we may decide to itemize, but these are the amounts of the standard deduction. We'll have to decide, we'll talk about later in the semester about Schedule A and itemizing our deductions. Head of household, what is the standard deduction for head of household?
87.
The standard deduction for a head of household is
8,700.
11,900?
No, 8,700.
Yes, 8,700. And for widow or widower is, with a dependent child, is 11,900. So let's put that here. Widow or widower with dependent. 11,000. So right away, we see that there's implications on the level of taxable income. So if we're single, we're going to reduce our income by not the amount, not our tax, not the amount of tax that we owe. This is a deduction. That's not the same thing as a credit. A credit reduces the amount of tax that you owe. A deduction reduces the amount of income. You follow? So a deduction and a credit are not the same thing. It would be better if this was a credit. That means if we owed taxes of $10,000, then we would subtract $5,950. What do we subtract this $5,950 from? From our income. Now, so look at the difference here. If we're single, our standard deduction is $5,950. If we're married and filing jointly, the standard deduction is $11,900. One of my students texted me the other day and asked me, Coach, should I file jointly or separately? I said, jointly. He said, oh, thanks. Now we're going to see why. Married filing separately is $5,950. So that means both spouses can get a standard deduction of $5,950. So you might be thinking, is it a wash? Like, wait a minute. So if I'm still getting $5,950, then, and my spouse is also getting $5,950, why do you think we should file jointly? Because we're still getting the same standard deduction. Yes, that's true. However, it seems that that's not what Congress wants us to do. So what we'll find, all right, so in general, it's better to file jointly because the tax rate, now this is not readily obvious to us, but the tax rate, and it says this in publication 17, that the tax rate for filing separately is going to be higher. So even though you're getting the same standard deduction, the tax rate is going to be higher. And the credits that are available to us are limited. So for example, if you're married filing separately, you can't take the education credit. So the American Opportunity Credit and Lifetime Learning Credit, you're not going to be able to take that.
One person can itemize.
One person can itemize, right? So there's definitely disadvantages. So besides these numbers, which when you first look at it, you might say, it's the same. We're still getting the same standard deduction. But I'm telling you that, no, it's not the same. On the surface, it seems like the same because the standard deduction is the same. But you're not going to be entitled to the same credits as if you file jointly. The tax rates in general are going to be higher. And there's also some income, some interest income that previously would have been exempt, like from savings bonds, that will have to now be included. So in general, it's beneficial if you file jointly. That means, what does beneficial mean? That you're going to pay less tax as a couple. So that's, keep that in mind as a general rule of thumb. Now, this is something that really fascinates people, is this idea of head of household. Even people who don't know anything about taxes, they know head of household, right? Why? Because they know that the standard deduction is much higher for a head of household than it is for single. So in order to be considered head of household, there's some criteria. So the IRS says, in the IRS code, Congress has indicated that the standard deduction for head of household, so that's a single person with a dependent, is $8,700. That's a very big difference, isn't it? Like about $3,000. You're going to reduce your income by about $3,000. So that might actually provide a tax shield of, depending on your tax bracket, of maybe about $1,000. So that's not insignificant. That's a very big difference. Okay, so what else? So as of the last day of the year, you are either unmarried or never married. So if your divorce decree went through by the end of the year, then you might be eligible for head of household. You paid more than half of the cost to upkeep your home, your household. So more than half. So whatever the key expenses are, the property tax, the mortgage, etc., you would have needed to pay more than 50% of those household expenses. And the qualifying person would have, which is either, the qualifying person is going to be either a qualifying child or a qualifying relative, would have had to live in your home for more than half a year. Except for what? What did I tell you last time? Except for your parents. So, your dependent, if your parents are your dependent, they don't need to live with you. Questions about that? Now, let me ask you a couple of quick points, and then we're going to get into this in more detail. What about if your parents that you support, right, they're your dependent, and we're going to get into what that actually means, but I want to bring to your attention a point. Your parents that you support and you feel are your dependents don't live with you. And in fact, not only don't they live with you, they live in Jamaica. All right? So they live in St. James, Montego Bay, Jamaica. Or Kingston. Right? So, what do you think? Assuming, and we'll talk about these tests, assuming they met these criteria, and remember we said they don't need to live with us, but they live in Jamaica. They're our parents, like those are our parents, and they don't live with us. The Congress says they don't need to live with us, but they live somewhere, not with us. It happens that they have a very nice home in Jamaica. Is that a problem? I see somebody shaking their head. So, what do you think, Tanya?
Don't they have to be in U.S. citizen?
Well, wait. Before we get to that. Yes or no?
No.
Right. So, they live in Jamaica? No, we can't. They're not. We can't claim them as a dependent. Now, what about if they live in Trinidad? No. France? Italy? Russia? Turkey? What about if they live in Turkey and they live in the city of Istanbul? No? How about if they're Pakistani and they live in Karachi? Can we claim them as independent? No? How about Mexico?
Yes.
What? Wait a minute, you sure?
Yes.
What? Pakistan? No. Trinidad? Partner? No. Jamaica? Yemen? No. Turkey? No. What about Mersin? If they live in Mersin? In Turkey? No? It's very warm there, you know, in Turkey. But if they're your parents and they don't live with you and they live in Mexico, then they might be eligible to be a dependent? Yes?
Yes.
Yes. So the answer is yes. So Mexico, yes, they might be eligible to for us to claim them as a dependent. What about Canada?
No.
So Canada, yes or no?
No.
So how many say no? And how many don't want to raise their hand? So wait a minute. And I'm just trying to, I want us to think this through. That's why I'm going about it this way. If they live in Mexico, if our parents live in Mexico and they meet these other criteria that we're going to talk about, you said that they might be eligible to be our dependent.
Yes.
So we agree, yes.
Yeah.
That's what it says in the tax code. If they live in Mexico, they might be eligible to be our dependent. You said Jamaica, no. Trinidad, no. Pakistan, no. Turkey, no. France, no. Italy, no. And then Canada, you also said no. Yes. Canada, yes. If your parents live in Canada and they meet the other criteria, then we might be able to take them as a dependent. That's what it says in the IRS code. So if they're a resident of Canada, of Mexico.
So those are, what about U.S. territories like U.S. Virgin Islands, St. Thomas, or even Puerto Rico?
So that they would be what, a U.S. national?
Yeah.
Yeah. So if they're a U.S. national, yes, right? If they're a resident alien, which is really code for green card, right? That's what we often refer to as the green card. So if they have a green card, they're a permanent resident of the United States, they're a resident alien, then they might be eligible to be our dependent, or if they're a U.S. citizen, certainly. So if they're a U.S. citizen, or even if they're not a U.S. citizen, but they're a U.S. resident alien, they might be eligible. Or they're a U.S. national, which is what Camille is bringing to our attention. And even if they're a resident of Canada or Mexico. Are we good?
So if you're a U.S. citizen but you live in a different country, you can still claim them as dependent?
Well, if they're if they're right, it's got to be either Canada, Mexico, or the United States, whether or not they're a U.S. citizen. So if they live in Mexico, do they need to be a U.S. citizen if they're our parents and they live in Mexico?
No.
What do you think?
Do they need to be a resident?
Yes, this is a
I think yes.
So they don't need to. So it's or. So what it says in the tax code is that you cannot claim them unless what? They're a U.S. citizen, a U.S. resident alien, so they have a green card, U.S. national. So they need to either be a U.S. citizen, a U.S. resident, or a U.S. national. And then it says, in publication 17, it says, or they're a resident of Canada or Mexico. So so if they live in Mexico, then I would think they're not, it's unlikely that they're going to be a U.S. citizen. I mean, they might be, but the way the code reads, it says, this is the criteria. The criteria says that in order for them to be eligible to be a dependent, right, they need to either be a U.S. citizen, a U.S. national, or a U.S. resident alien, which means they have a green card. Or they live in Canada, they're resident of Canada or Mexico. So if they live in Canada or Mexico, then it's no longer relevant if they're U.S. citizen or not, or they have a U.S. resident alien card, or they're U.S. national. The Congress, the way they wrote the IRS code, and we see it in publication 17 in chapter 3, it says that you can reside in Canada or Mexico. So what is the rationale behind it? You may say, well, I don't really get this. But remember, everything that Congress has in the code, remember what I was saying before, has a motivation. There's a reasoning behind it. There's some purpose. There's some incentive for the taxpayer, or some disincentive, or some political position that Congress is advancing. So, North America, the North America continent has 3 countries: Mexico, Canada, and the United States. The United States has entered into an agreement with Canada and also with Mexico to have free trade. What's that agreement known as? Okay, come on.
NAFTA?
Yes, right. NAFTA, which is the free trade agreement, North American Free Trade Agreement. So what that means is that when trading amongst those nations occurs, there's no tariffs. What Congress and also the other governments of Mexico and Canada agreed to is that we need to find a way, we're all on this continent, this North American continent, we believe that we should increase the amount of trade that occurs amongst these 3 countries. And so that's what NAFTA is intended to do, is to increase the level of trade amongst those 3 nations, US, Canada, and Mexico. So when trading, there's no tariffs. What's a tariff? Basically,
It's
a tax. Basically, it's a tax. So the way countries use tariffs is to make imported goods more expensive in the domestic market. Now, what the governments agreed is that, you know what, let's level the playing field. Let's, amongst ourselves, and it's going to be a win-win, regardless of whether or not U.S. exports increase. As a world economy, it's not in anybody's advantage, certainly not in North America, for Mexico to be in financial crisis. So maybe our exports, the U.S. exports, are going to decline. But if that means that exports for Mexico goes up, and the Mexican economy strengthens, that's a good thing. Especially in Mexico, because Mexico has been experiencing financial crisis for a very long time. So even if we look back like 20 years and plus, I mean, in fact, NAFTA goes back at least 20 years. And now we could sit back and look and say, did it work? Did it achieve its goals? But financial crisis in Canada, in Mexico, is something that needs to be solved. So NAFTA is one way that that's trying to be addressed. So is it win-win? Right? Something to think about. What is actually the benefit for Canada or for the United States? Because their exports might actually decline. If there's no tariffs on Mexican goods, then maybe Canadians and Americans are gonna, what? Buy more Mexican products. And if they're buying more Mexican products, that means they're probably buying less Canadian and American products. And you're like, oh, hell no. But yeah, we need to fix that problem. Financial instability in Mexico is unacceptable. We need to address that as a world economy. That needs to be addressed. So, in terms of taxes now, in terms of income tax, Congress says, yep, we were there. We were there when NAFTA was signed more than 20 years ago, and we understand what the goal is of that free trade agreement. And we're going to allow dependents, to live in Canada or Mexico. So the code says that if they live in Canada or Mexico, they might meet the criteria for being our dependent. If they live in the United States, then they have to either be a U.S. citizen, a U.S. resident alien, or a U.S. national. But Canada and Mexico, not any of the countries that we mentioned, and any of the others. So, or, the IRS code, you know, you have to pay attention to like or versus and. So in this case, it makes a big difference. It says either or. Either they have this citizenship status, or they don't. Or they're a resident alien or a U.S. national. But if they don't, maybe they are a resident of Canada or Mexico. Questions?
What if they live, they're U.S. citizens or they have green card, but they lived in the U.S. for 6 months and then they moved to another country for the next 6 months?
So, so which criteria is going to apply? So 6 months, they live in the United States, and then what? Then where do they move to?
Another country that doesn't.
Well, it matters. We got to know, so you got to give us an example that's Jamaica. Okay. How come you didn't say Trinidad? All right, so it's not Canada, it's not Mexico, and so that criteria is irrelevant now. So we have to go back and say, are they a U.S. citizen, right? A U.S. resident alien or a U.S. national? Are they? So, what do you think? Are they gonna, is it possible that they can be our dependent? What do the rest of you think?
Yeah.
Depends on the rest of the test.
What was that?
Depends on the rest of the test. We still got to test.
Well, remember, it doesn't say and. It doesn't say you have to meet both criteria. It says or. So, what do you think?
Yes.
Yes? That's your answer, Camille? You sure?
It is or.
Yeah. What do you think, Corinne? Yes? Yeah. I think in the situation that you described, I would say, yeah, you could, you would be able to potentially claim them as your dependent. So now let's look at what are the criteria for a qualifying person. So for a dependent, if the person is going to be our dependent, if we're going to claim them as a dependent, which very often when people are filing their taxes, they're looking for dependents, right? They want to have 2, 3, 4, 5, 6 dependents that they could list. You have to provide their name and also their social security number, which means that a person can't be a dependent on 2 people's tax return. So if you're married and you're filing separately, you both can't take the same dependent. You have to agree amongst yourself. So the IRS is not going to get involved in that. You have to agree amongst yourself. And it's very easy, the way these returns are processed electronically, the system can pick up social security numbers very easily. So it knows, oh, well, this person was claimed on 600 people's return. How is that possible? But people do things like that. But what's the motivation? Why is that something that people are interested in? When people always talk about dependence, is because you could get an exemption, right, which is going to reduce our taxable income by $3,800 in 2012. So for each, now we have a personal exemption, which is ourself, right? So we have a personal exemption. So we're able to take $3,800 for ourselves as a personal exemption. So remember, the exemption is separate from standard deduction or itemized deduction. We get an exemption. And then we say, well, I think we have some dependents in my household, other than my parents, who don't need to be part of our household. It needs to be either a qualifying child or a qualifying relative. Now let's talk about what that is. All right, are we going to do this? You guys ready? You can do it. Yes, you can. But we got plenty of time. We're here until midnight. Okay, so this is actually very interesting. You guys don't need a break, right? You're good? Let's just keep going. Let's make it happen. All right. Something else I wanted to mention about being married. So let's suppose that you're married and then your spouse passes sometime during the year. So your spouse dies sometime during the year, and so you forget about this divorce thing. Spouse died. Actually simplifies things, right? A lot of stress. Now, pick a month, any month. It doesn't matter. If your spouse passes in January, February, March, April, May, June, July, August, September, October, November, December, whether it's January 1st or December 30th, your spouse dies. So now you're going to say, wow, am I single or am I still married? So the answer is, now this is a unique situation. Your spouse passes. This is a little bit different from what we talked about in terms of whether or not you're single because of divorce. So if your divorce is finalized by the end of the year, then what did we say? We said that you're single. As of the last day of the year, your divorce decree was finalized, you are single. So you're either going to file as single, or maybe you might qualify as head of household. Now, follow me here. But in this situation, it's not a divorce that's involved, it's death. The Congress said in the IRS code that if your spouse dies during the year, then even if it's January 1st, the very beginning of the year, then you are considered married for the entire year. Are we all on the same page now? So that's different. See, this is a different rule, different from what we just discussed about what it means to be single. I said if you're single or if you're married, it depends on what your status is by the last day of the year. So if your divorce decree is finalized by the last day of the year, then you're single. So the last day of the year, you're single. Now, if your spouse dies on January 1st, then what that means is by the last day of the year, you're single. Yes?
Yeah.
You're single. That's like a separation. That's it. Until death do us part. So now you are no longer married, but the IRS, the IRS code says that if at any time during the year you are married and your spouse dies, then you are considered married for the entire year. Now, that's the IRS's attempt at trying to be fair, because we saw here that we've discussed that filing jointly has tax advantages. Now, if you get married, like if the guy dies on January 1st and then January 15th you remarry, I don't know, maybe I'm watching too much Judge Judy, but apparently these things happen, according to Maury Povich. Maury, you know Maury? Yeah. Because one of those 15 guys is the father of that child. Yes. So we have to decide whether or not the child is our dependent. So if you remarry, then that's a different set of circumstances. But if your spouse dies, then you're considered married for the entire year. So I wanted to point that out. That's important for us to know.
Even if they die on January 1st, it's still
Right.
there. Yeah.
Right. So as they die the first day of the year, I see the wheels are turning. Watch out. We're going to have a black widow on our hands here. Yep. Then you would be, you're considered to be, even though 364 days out of that year you were actually unmarried, the IRS says we will allow you to file as married.
So that would be what?
So it's allowed, but not must.
Filing what?
What?
It's allowed, but it's not a must.
Well, let's see. If the IRS says that you're considered married, then that's your status. Now, you're saying, well, could I file single if I want? Well, I mean, you could, take, you could do anything you want. You could do whatever you want, but if the IRS says that we feel that you are still married.
For this year or rest of the life? Like, how about 2013?
No, okay, that's a good question. So, 2 years, for 2 years after the passing of your spouse. So why does IRS do that? So as a widow or widower, for 2 years you could file as married.
Give that person relief.
Say it a little bit louder.
To give that person tax relief.
Yeah, to give you, it's gonna reduce your, the amount of tax that you're ultimately gonna owe. So they understand that, right? Because if you're single, this is your standard deduction. If you're married, they say, well, even though they passed, we'll let you still take a standard deduction. So like Muhammad is saying, well, it provides some tax relief. It's going to reduce the amount of tax that's owed. And if you don't remarry, you could file a joint return. With your deceased spouse. So, I think that's what they're asking along, right? Is you will file a joint return. So it's as if you're going to see the benefits of you're going to see the benefits of being married even though your spouse is deceased. So, Alicia, you would file married, filing jointly. Now, you were saying, well, what if I want to file single? But I don't know, like, this says Why would you want to do that? Because right away, the first thing is we see this huge difference, like almost $6,000 difference in the standard deduction. So the tax shield, if you're in a 30% tax bracket, is going to be approximately $2,000. So that means you're going to pay like $2,000 more in tax. So that's why Muhammad is saying, well, yeah, you're going to get some relief because that $2,000 is, instead of paying it to the IRS, you're going to have a lot of expenses. You know, funerals, we're not even talking about Ed Koch funerals. We're just talking about everyday funerals are like $10,000. That like doesn't even include the flowers. So it's expensive. And the government says, hey, we're not mean. We're not as mean as you think. We write the tax code to instill, well, like I said before, to either achieve certain behavior, which is either an incentive or a disincentive, or to achieve some public good, or to reinforce some political policy. So in this case, you're absolutely right. They're thinking, wow, we do have a heart. Their spouse died, so let them still file jointly so they could realize the tax shield. That's what we call that. That's ultimately the tax shield. So your taxable income is going to be reduced by that additional $5,950, which means that the tax shield is going to be, if you're in a 30% tax bracket, well, approximately 30%, whatever tax bracket that you're in, is going to be approximately $2,000. So I think you should file after your spouse is gone. Adios! Still file jointly. The IRS says you can still file jointly.
So you would have to use their income, the deceased spouse's income, right?
Yes.
Okay.
So if you'll still have to pay tax on whatever income they had.
Well, you said you could do it for 2 years, so what about the following year? He has zero income. He's there, he didn't work.
If they have, if they don't have any incomes, or that, or it goes to, if they have no income, they have no income. If they might, it depends on how that gets resolved. If the assets transfer immediately to the spouse, or if it goes into a trust, or there's some type of probate, other parties are involved and so forth. But in most cases, the assets of a spouse are shared. So whatever investments they had, it's going to be the responsibility now, if it's generating income of any sort, for the other spouse to pay. So by the way, important to note that, that when you're married, the IRS they don't make any distinction about, like, oh, well, my wife, Corinne, she didn't pay taxes. They're like, we're not trying to hear that. Get her in check. All we're interested in is the money. So if she doesn't pay, you're going to pay. And you're like, what? Then yeah, that's right. So your spouse died, whatever, it's like irrelevant. If your spouse owes money, then you owe money. And by the way, what if your spouse owed money? Actually this is a common issue, especially like in messy divorces, is that you have your spouse, they want to get divorced, and they owe the IRS money. So the IRS says, well, that's not going to be our problem. That's your spouse. So whether it's you or your spouse that owes, you have to pay. Someone's going to pay. If your spouse doesn't pay, wherever they go, can't be found. And this is really sad, because this actually does happen. You have like deadbeat spouses who they don't pay their tax, and then they get a divorce, and they just walk away. They go like into hiding, whatever, they disappear, like a new identity or wherever it is, they're like missing in action, and the IRS says, well, your spouse owed, so you have to pay. If your spouse owed, it's like you owe. Yes, Camilla?
In this case, can't you file the injured spouse form or something like that?
As if you didn't.
That was a good question.
The injured spouse form and? Go ahead.
That's it.
That's it. That's all you got. And so if you file the injured spouse form, then what?
Then, because in some cases, if you file separately, like some people file separately because one of the spouse owes some money to the IRS, or no, they file it jointly and one of the spouses owes something or has some expenses, then it's recommended to file that injured spouse form so other spouse wouldn't be affected.
But that's if you knowingly, like, really didn't know the spouse was underestimated or doing something.
Okay.
But you said specifically injured, right? Is that?
It's called injured spouse form. It's
Isn't it?
I mean, it does, that spouse doesn't have to be physically injured.
No,
The spouse doesn't have to be injured as a result of.
No, I think what she's saying is that, let's say, for example, you're filing a joint return with your spouse, right? You know that this person, as you said, is a deadbeat spouse. They probably took out a student loan way before you were even married, and they owe that loan. So now you're filing a joint return. So what she's saying is that you could file that non-injured spouse form along with your taxes, so that you don't be liable for that loan that the spouse took out years ago, and is still owing.
So who's that agreement going to be between?
You
and the IRS, or
Yeah.
you and
The
the deadbeat
IRS.
spouse, or
and IRS.
really? And the IRS is going to go along with
Yeah,
that?
it's like if
A lot of people
if the debt was there
It has
before you
happened.
get married, and like you're saying, if the spouse, you know, accumulated that debt prior to the marriage, then you can file that form to say that you did not know about this, so you shouldn't be held liable for it.
And so what about after you're married? What's going to happen then? So you're married and your spouse doesn't take any withholding. Maybe they, they do consulting, and they have income, and their clients are reporting that income to the IRS. Then, but they don't pay any tax. Then what's going to happen?
Oh, that's different now.
That's
Because
different.
you should know your spouse's income, what he's taking it.
Well,
what your
the-
taxes are.
The attitude of the IRS is they're not really even really trying to get into that, whether you should know or shouldn't know. It's just like, we don't want to, we're not going to get caught holding the bag. You're married. I remember, I think this was like maybe 5 years ago or 6 years ago, I told students, I said, hey, just to break it up a little bit in class, I said, do you want to see a picture of my son? You see? And they said, like in unison, they said, "You're married?" And I said, "Hello, this is 2007. I didn't say I was married. I said, you want to see a picture of my son? That's different, right?" So you don't need to be married to be head of household, right? You could still be single and have a child that's your dependent, which in my case is a miniature dachshund who likes to chew on shoes and make a mess. Yeah. So if you're married, and in the U.S. we've been talking a lot about what constitutes marriage and domestic partnerships, and a tremendous issue in our country. The IRS says, well, I hope you're happy now. You wanted to. So Janelle was asking, why don't we say 18 instead of saying less than 19? Well, just keep in mind that less than 19 would mean 18 and a half, 18 and 3/4. That's gonna be allowing us to meet the age test. So it's not up until 18, it's up until 19. So if you're 18, 11 months, and 28 days, whatever, then you're at the end of the year, at the end of that year, then you would meet the age test. But we have to meet the relationship test, the age test, and then we just started to talk about the residency test, which is the qualifying child had to have lived with us for more than half the year, which is more than 6 months. And how many days is that? How many? A lot?
163. 181 days.
So like, what is it? Like at least, it has to be more than 182 days, right?
With the qualifying widower, the child has to be living with you for the full year.
Oh, let's not go there right now. Right now. Let's focus. So, more than half the year. And remember, I was just saying, well, with student, so student is up till 24. They meet the age test. And now with residents, the reason why I say it's important for us to take note of the student is because a student, let's say we live in New York, and we send the student, our child, right, our qualifying child, which could be any of those, right? We send them to Indiana so that they could pursue a 60-credit MBA at Purdue University. And they're less than 24 years old. That's known as temporary absence. Temporary absence. Do they live in our household? No, we live in New York. They're studying in Indiana. You guys heard of Purdue University? Not Purdue Chicken. That's something else. Purdue University is a huge state university in Indiana. Very highly regarded. Very well known for engineering and also for their MBA program, which ranks among the top 3% of all MBA programs in the United States. So if our qualifying child moves from New York to Indiana to enroll in this full-time program, and they're less than 24 years old, that's considered to be a temporary absence. We expect them to come back. Congress says that that's a temporary absence. They don't live in our house. We don't set a plate for them at dinner. They're away from home. What do you think? Is that fair?
No, because you're taking care of them while they're over there.
But, so the IRS says, the IRS code says, while they're in Indiana, if they're a qualifying child, and they're less than 24 years old, and they're a student, a full-time student in Indiana, and they meet the support test, then we can claim them as a dependent. So even though there's that temporary absence, even though they're not living with us, right? So you don't need to clean their room.
What if they're in school in Mexico?
Oh. That's a good question. What do you think about that?
You see. You see.
Hmm?
You see.
It's
It's a trade.
He says it's free.
as long as like the parents.
So if they're a qualifying child, there's a temporary absence, what do you think? Would it matter where they were?
No, because the parent.
Because what?
I mean, if they meet all the tests that's required to be a qualifying child, and a lot of parents send their children away to college, and they still have expenses. Like they pay tuition, they pay for dorm, housing expenses.
So you're saying that
Citizens.
Right.
if they're not a U.S. citizen, if they're not a U.S. national, if they're not a U.S. resident alien, then they could only study in either the United States, Canada, or Mexico.
Or what about study abroad?
Yeah, study.
That is study abroad.
I mean, like say
International.
Yeah, I'm talking about like Europe.
So that's what we're trying to clarify. So what do you think? So
I think it is.
suppose it's not Canada or Mexico.
Italy.
So they're doing study abroad in Italy, in China.
And they're not a U.S. citizen or U.S. national. That's what you said. Right?
Well, so that's in that scenario.
That's it.
We have different scenarios. One scenario is that they are qualifying. But let's go step by step. They meet the relationship test. They meet the age test. They do not provide more than half their own support. Now that's interesting. Why is that? They do not provide more than half their support. Why that's interesting is because it doesn't say we provide more than half their support. It just says that they don't provide more than half of their own support. It doesn't say who provides it. It could be your professor who gives your qualifying child a scholarship. It says that if the qualifying child is a dependent, they don't provide more than half their support. The criteria doesn't say that we provide more than half their support, or that we provide half their support. You see where I'm going with that? The code is defining what it means to be a qualifying child. And one of the tests is the support test. So, do we need to provide more than half the child's support?
Yes.
No, he just said.
It doesn't. That's not what the IRS code says in publication 17 in chapter 3. It just says that the child could be considered a dependent if the child did not provide more than half of his or her own support during the year. See, that's interesting. Maybe your ex-husband is paying for it. It's just that, how do we define the nature of the dependency? Well, they're not supporting themselves. That's one of the tests. It has to do with support. Now, so are we going to resolve this other issue tonight? What about if the qualifying child is less than 24 years old and they don't provide more than half their support and they're doing study abroad in China? Corinne, what do you think?
Qualified child.
They can still
How
be a
long are they
qualified
staying living abroad? Wouldn't they still be covered under the
The
temporary
temporary
absence?
absence, yeah. Unless
So,
they work to-
Is it gonna matter? So they could do study abroad in China? Yes, I would say that as a qualifying child, if they meet the other criteria, then if there's a temporary absence, if they're doing study abroad, like you said, and it's not Mexico or Canada, then they would still meet the residency test.